Welcome to Know Your Rights University, where we would like to share once again with you information that we feel is informative and educational, and we feel it may assist you in understanding our current condition in society as it pertains to legal rights and duties. So, we're reading from a document called What is a Legal Duty and How Does It Pertain to Individual Rights? Legal duty, an obligation arising from contract of the parties or the operation of the law. Example, legal duty of husband to support wife and children. That which the law requires to be done or forborne to a determinate person or the public at large, correlative to a vested and coextensive right in such person or the public, and the breach of which constitutes negligence. See also legal obligation. Support Black's Law Dictionary, 5th edition. Whether a legal duty exists is a question of law and is determined by reference to whether the parties stood in such a relationship to each other that the law imposes an obligation on one to act for the protection of the other. Undertaking, a promise, engagement, or stipulation. An engagement by one of the parties to a contract to the other, as distinguished from the mutual engagement of the parties to each other. It does not necessarily imply a consideration. In a somewhat special sense, a promise given in the course of legal proceedings by a party or his counsel, generally as a condition to obtaining some concession from the court or the opposite party, a promise or security in any form. See stipulation. Black's Law Dictionary. Fiduciary. The term is derived from the Roman law and means, as a noun, a person holding the character of a trustee, or a character analogous to that of a trustee, in respect to the trust and confidence involved in it, and the scrupulous good faith and candor which it requires. A person having duty created by his undertaking to act primarily for another's benefit in matters connected with such undertaking. As an adjective, it means of the nature of a trust, having characteristics of a trust, analogous to a trust, relating to or founded upon a trust or confidence. A person or institution who manages money or property for another and who must exercise a standard of care in such management activity imposed by law or contract. Example, executor of estate, receiver in bankruptcy, trustee. A trustee, for example, possesses a fiduciary responsibility to the beneficiaries of the trust to follow the terms of the trust and the requirements of applicable state law. A breach of fiduciary responsibility would make the trustee liable to the beneficiaries for any damage caused by such a breach. The status of being a fiduciary gives rise to certain legal incidents and obligations, including the prohibition against investing the money or property in investments which are speculative or otherwise imprudent. Many states have adopted the Uniform Fiduciaries Act, Uniform Management of Institutional Funds Act, and the Uniform Simplification of Fiduciary Security Transfers Act. Black's Law Dictionary, 5th edition. The word fiduciary as a noun means one who holds a thing in trust for another. A trustee, a person holding the character of a trustee, or a character analogous to that of a trustee with respect to the trust and confidence involved in it and the scrupulous good faith and candor which it requires. A person having the duty created by his undertaking to act primarily for another's benefit in matters connected with such undertaking. Also, more specifically in a statute, a guardian, trustee, executor, administrator, receiver, conservator, or any person acting in any fiduciary capacity for any person, trust, or estate. 36A, Corpus Juris Secundum, Fiduciary, page 381. One is said to act in a fiduciary capacity or to receive money or contract a debt in a fiduciary capacity when the business which he transacts or the money or property which he handles is not his own or for his benefit, but for the benefit of another person, as to whom he stands in a relation implying and necessitating great confidence and trust on the part on one part and a high degree of good faith on the other part. The term is not restricted to technical or express trusts, but includes also such offices or relations as those of an attorney at law, a guardian, executor, or broker, a director of a corporation, and a public officer. Interesting. Black's Law Dictionary, 4th edition. Fiduciary capacity. And there's some case law. Fraud in its elementary common law sense of deceit. And this is one of the meanings that fraud bears in the statute. See United States versus Dial. It's a 1985 case of the 7th Circuit Court of Appeals in the U.S. District Court of Appeals. It includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, including in the case of a judge, the litigants who appear before him, and if he deliberately conceals material information from them, he is guilty of fraud. When a judge is busy soliciting loans from counsel to one party and not telling the opposing counsel, let alone the public, he is concealing material information in violation of his fiduciary obligations. Now that's very interesting. I wonder if when a judge in a case hides information about the nature and cause of the charges being brought against a defendant, is that considered a violation of his fiduciary obligation? That's something to ponder on. Let me know in the comments what you guys think, if that is such a violation of his fiduciary obligations for a judge to hide, the nature and cause of the allegations being brought against a defendant in a civil or a criminal case. Let us know in the comments. Let us go on. Let us quote the preamble of the Constitution for the United States of America. We the people, of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Before going into the contents of the Constitution for the United States of America, let us look at the 7 basic principles of the Constitution. 7 basic principles. The Constitution rests on 7 basic principles. They are popular sovereignty, limited government, separation of powers, federalism, checks and balances, republicanism, and individual rights. Popular sovereignty. The framers of the Constitution lived in a time when monarchs claimed that their power came from God, or divine right of kings. The preamble, with its talk of we the people, reflects a revolutionary new idea that a government gets its authority from the people. This principle, known as popular sovereignty, states that the people have the right to alter or abolish their government. Limited government. The colonists had lived under the harsh rule of a king. To avoid such tyranny in their new government, the framers made limited government a principle of the Constitution. In a limited government, the government has only the powers that the Constitution gives it. Just as important, everyone from you to the president must obey the law. Separation of powers. To further limit government power, the framers provided for separation of powers. The Constitution divides the government into three branches. Congress, or the legislative branch, makes the laws. The executive branch, headed by the president, carries out the laws. The judicial branch, composed of the courts, explains and interprets the laws. Checks and balances. A system of checks and balances safeguards against abuse of power. Each branch of government has the power to check or limit the actions of the other two. You will read more about checks and balances in Section 2. Federalism. The Constitution also establishes the principles of federalism, or division of power between the federal government and the states. Among the powers the Constitution gives the federal government are the power to coin money, declare war, and regulate trade between the states. States regulate trade within their own borders, make rules for state elections, and establish schools. Some powers are shared between the federal government and the states. Powers not clearly given to the federal government belong to the states. Republicanism. The Constitution provides for a republican form of government. Let me read that again. The Constitution provides for a republican form of government. One more time. The Constitution provides for a republican form of government. Instead of taking part directly in government, citizens elect representatives to carry out their will. Once in office, representatives vote according to their own judgment. However, they must remain open to the opinions of the people they represent. For that reason, members of Congress maintain offices in their home districts and often websites as well. Individual rights. The Constitution protects individual rights, which are basic freedoms the government agrees to protect. Examples of these rights are freedom of speech, freedom of religion, and the right to a trial by jury. You will read more about the rights protected by the Constitution later in this chapter. Through checks and balances, each branch of the government limits the power of the other two. Executive branch. President carries out the laws. Checks on the legislative branch. Can propose laws. Can veto laws. Can call special sessions of Congress. Makes appointments. Negotiates foreign treaties. Checks on the judicial branch. Appoints federal judges. Can grant pardons to federal offenders. Legislative branch, Congress makes the laws. Checks on the executive branch. Can override president's veto. Confirms executive appointments. Ratifies treaties. Can declare war. Appropriates money. Can impeach and remove president. Checks on the judicial branch. Can create lower federal courts, can impeach and remove judges, can propose amendments to overrule judicial decisions, approves appointments of federal judges. Judicial branch, Supreme Court interprets laws. Checks on the executive branch, can declare executive actions unconstitutional. Checks on the legislative branch, can declare acts of Congress unconstitutional. To the founding generation, the liberties of speech and press were intimately connected with popular sovereignty and the right of the people to see, examine, and be informed of their government. For example, In one of the most famous 18th century essays on the freedom of speech, Whig commentator Thomas Gordon explained that men ought to speak well of their governors is true, while their governors deserve to be well spoken of. But to do public mischief without hearing of it is only the prerogative and felicity of tyranny. A free people will be shewing that they are so by their freedom of speech. The administration of government is nothing else but the attendance of the trustees of the people upon the interests and affairs of the people. And as it is the part and business of the people, for whose sake alone all public matters are or ought to be transacted, to see whether they be well or ill transacted, so it is the interest and ought to be the ambition of all honest magistrates to have their deeds openly examined and publicly scanned. Silence Dogood, number 8. The New England Courant, Boston, July 9, 1722, were printed in the papers of Benjamin Franklin. Other colonial writers stressed the necessity and right of the people to be informed of their governor's conduct so as to shape their own judgments on public matters and be qualified to choose their representatives. Leonard W. Levy, Emergence of a Free Press, 134, 2004. The Virginia General Assembly objected to the infamous Sedition Act of 1798 in part because it is leveled against the right of freely examining public characters and measures and of free communication among the people thereon. Virginia Resolutions of 1798 were printed in the papers of James Madison, 189 through 90. David B. Mattern et al. ACLU versus Alvarez. That right there is a case concerning freedom of the press and of free speech. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. There's a case citation. The theory is that a public officer assumes the same fiduciary relationship toward the citizens of his community as a trustee bears to his Sesticate trust. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. Section 3A of the Corrupt Practices Act states, no person holding any office, either by election or appointment under the laws or constitution of this state, Illinois that is, may be in any manner interested either directly or indirectly in his own name or in the name of any other person, association, trust, or corporation in any contract or the performance of any work in the making or letting of which such officer may be called upon to act or vote. The legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interests and their fiduciary duties. There is a case citation. Elements of breach of fiduciary duty. Under Illinois law, upon which this theory is based, recovery for a breach of fiduciary duty requires proof of 3 elements. 1, a fiduciary duty exists. 2, that the fiduciary duty was breached. And 3, that such breach proximately caused the injury of which the plaintiff complains. It has long been established in Illinois that a public officer occupies a fiduciary relationship to the political entity on whose behalf he serves. The most well known of a public official's fiduciary duties is that of undivided loyalty to the office and the people whom he serves. Emanating in part from Section 3 of the Illinois Corrupt Practices Act, this duty is sweeping and commands a public official to refrain from self-dealing and conflicts of interest. The duty of loyalty is not the only fiduciary duty Illinois recognizes for its public officials. Other duties may be prescribed by statute or found in common law. The right to a civil remedy for breach of a statutorily created fiduciary duty is clear. In 63C, American Jurisprudence on Public Officer, Section 3, Nature as Public Trust or Agency, West Key Number Digest, Officers and Public Employees 1 states, every public office is created in the interest and for the benefit of the people and belongs to them. Thus, a public office is a public agency or trust created in the interest and for the benefit of the people. Such trust extends to all matters within the range of the duties pertaining to the office. Section 4. Generally, the characteristics or elements of a public office include its creation by law, that is, by statute or constitution, the designation of the position as an office, the prescription of the qualifications and duties of the appointee, the exercise of some portion of the sovereign power, a permanent or continuing position, not occasional or contractual, a fixed term of office, oath and bond prescription or requirements, liability for misfeasance or nonfeasance, and an independent of the official beyond that of employees. Section 33-3 of the Criminal Code of 1961 states, a public officer or employee commits misconduct when, in his official capacity, he commits any of the following acts. A. Intentionally or recklessly fails to perform any mandatory duty as required by law, or B. Knowingly performs an act which he knows he is forbidden by law to perform, or C. With the intent to obtain a personal advantage for himself or another, he performs an act in excess of his lawful authority, or D. Solicits or knowingly accepts for the performance of an act a fee or reward which he knows is not authorized by law. A public office is a position in a governmental system created or at least recognized by applicable law to which certain permanent duties are assigned, either by the law itself or by regulations adopted under the law by an agency created under such law and acting in pursuance of it. A public office has also been defined as occasional or incidental, by which for a given period an individual is invested with power to perform a public function for the benefit of the public. A position is held to be a public office when it has been created by law and casts upon the incumbent duties which are continuing in their nature and not occasional, and which call for the exercise of some portion of the sovereignty of the state. Thus, an office is a public charge, where the duties are continuing and prescribed by law and not by contract, and the office holder is invested with some of the functions pertinent to sovereignty or having some of the powers and duties which inhere with the legislative, judicial, or executive departments of the government. Public offices are created for the purpose of effecting the end for which government has been instituted, which is the common good, and not for the profit, honor, or private interest of any one person, family, or class of persons. 63C, American Jurisprudence, Public office definitions. In addition, in a case called In Re, Associate Judge Lewis versus Morgan Jr., held before the Illinois Courts Commission, it was held, the judicial article of the Illinois Constitution provides in pertinent part, Section 13, prohibited activities. A. The Supreme Court shall adopt rules of conduct for judges and associate judges. B. Judges and associate judges shall devote full time to judicial duties. They shall not practice law, hold a position of profit, hold office under the United States or this state or unit of local government or school district or in a political party. Section 14, judicial salaries and expenses. Fee officers eliminated. Judges shall receive salaries provided by law, which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state, except that appellate, circuit, and associate judges shall receive such additional compensation from counties within their district or circuit as may be provided by law. There shall be no fee officers in the judicial system. Illinois Constitution of 1970, Article 6, Sections 13 and 14. The General Assembly has provided with respect to prohibited interest in contracts. Section 3, prohibited interest in contracts. No person holding any office, either by election or appointment under the laws or constitution of this state, may be in any manner financially interested directly in his own name or indirectly in the name of any other person, association, trust, or corporation in any contract or the performance of any work in the making or letting of which such officer may be called upon to act or vote. No such officer may represent, either as agent or otherwise, any person, association, trust, or corporation with respect to any application or bid for any contract or work in regard to which such officer may be called upon to vote. Nor may any such officer take or receive, or offer to take or receive, either directly or indirectly, any money or other thing of value as a gift or bribe or means of influencing his vote or action in his official character. Any contract made or procured in violation hereof is void. This section shall not apply to any person serving on an advisory panel or commission, to any director serving on a hospital district board as provided under Section A-5 of Section 13 of the Hospital District Law, or to any person serving as both a contractual employee and as a member of a public hospital board as provided under Article 11 of the Illinois Municipal Code in a municipality with a population between 13,000 and 16,000 that is located in a county with a population between 50,000 and 70,000. Illinois Supreme Court Rules. Canon 1. Rule 1.1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Canon 1, Rule 1.2. Promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Comments. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. It's interesting, as a side note, when we think of, I believe it's in the federal, it pertains to federal judges, but this here that we're reading pertains to state judges, particularly in Illinois. But I believe it's in the, I think it's 28 USC 455A. where this is kind of, in congruence with. But let us go on. Number two, a judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code. Number three, conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. Number four, judges should participate in activities that promote ethical conduct among judges and lawyers, support professionalism within the judiciary and the legal profession, and promote access to justice for all. Number five, actual improprieties include violations of law, court rules, or provisions of this code. The test for appearance of impropriety is whether the conduct will create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve as a judge. Number six, a judge should initiate and participate in community outreach activities for the purpose of promoting public understanding of and confidence in the administration of justice. In conducting such activities, the judge must act in a manner consistent with this code. Canon 3, Rule 3.15. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligation of judicial office. Rule 3.15, Reporting requirements. A judge shall file annually with the clerk of the Illinois Supreme Court a verified written statement of economic interest, the contents of, and filing deadline for the statement shall be as specified by administrative order of this court. Administrative order. The verified written statement of economic interest referred to in Rule 3.15 shall be filed annually by all judges on or before April 30th. Statements also shall be filed by every person who becomes a judge within 45 days after assuming office. However, judges who assume office on or after December the 1st and who file the statement before the following April the 30th shall not be required to file another statement until the next year. Before the first Monday in March of each year, the director of the administrative office of the Illinois courts shall inform each judge of the requirements of Rule 3.15, and this order and shall provide a copy of the statement of economic interest. The director shall do the same for each new judge within 10 days of the judge assuming office. This sounds like it's in line with the conflict of interest statute, and it's to make public record of the judge's financial interest or statement of economic interest so that the people may examine it and see if the judge has a conflict of interest in any case. Number three, the clerk is authorized to redact any personal information that is not required to be disclosed in the statement. The clerk shall maintain a publicly available list of all judges and the last date on which each judge filed the statement. The clerk shall send a judge acknowledgement of receipt of the judge's statement and the date of filing. 6. All statements shall be made available to the public by written request submitted to the clerk's office. Each person requesting a statement must fill out a form prepared by the director specifying the statement requested, identifying the examiner by name, occupation, address, telephone number, and email address, and listing the date of and the reason for the request. Copies of statements will be supplied to persons requesting them on payment of a reasonable fee per page as required by the clerk. Payment will be in the form required by the clerk. When a copy of a judge's statement is requested, the clerk shall promptly send the judge a copy of the completed request form. In the case of the people of the state of Illinois versus Wilbur Charlo, it was held, as we have said, the judicial role in construing statutes is to ascertain legislative intent and give it effect. To aid in accomplishing this, a court will seek to determine the objective the legislator sought to accomplish and the evils it desired to remedy. We have no quarrel with the conclusion at which the appellate court arrived by using these principles of statutory construction. It found that the legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interests and their fiduciary duties. We find, however, that the appellate court erred in not applying these sweeping prohibitions to defendants' conduct. Conflict of interest. The conflict of interest theory is based on the fact that an individual occupying a public position uses the trust imposed upon him and the position he occupies to further his own personal gain. And it is the influence he exerts in his official position to gain personally in spite of his official trust, which is the evil the law seeks to eradicate. In the case of Wright versus D'Armand, it was held, conflict of interest statutes address a problem of compelling importance to a state's capacity to govern justly, preventing political corruption or the appearance of corruption. In Corpus Juris Secundum, we read, Section 1, Trust. A trust is defined as the right enforceable solely in equity to the beneficial enjoyment of property, the legal title to which is vested in another. But the word trust also is frequently employed to indicate duties, relations, and responsibilities which are not strictly technical trusts. In general terms, a trust may be defined as a right enforceable in equity to the beneficial enjoyment of property, the legal title to which is in another. Specifically, a trust is a fiduciary relationship with respect to property subjecting a person by whom the property is held to equitable duties and or obligations to deal with the property for the benefit of another. In a popular sense, the word trust covers many things besides legal technical trust and is frequently employed to indicate duties, relations, and responsibilities which are not strictly technical trusts. However, properly speaking, in order to give rise to a trust, there must be something more than a confidence reposed by one person in another. Similar definitions. Number 1, a trust is any arrangement which exists whereby property is transferred with an intention that it be held and administered by the transferee or trustee for the benefit of another. Number 2, a trust is an equitable obligation, either express or implied, placed on a person by reason of a confidence placed in her or him to hold the property for the benefit of some other person or for the benefit of the trustee and others. Then we read in Weiss's Concise Trustee Handbook, first, it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. The classification applied to a trust is based upon its mode of creation, in which it may be created by act of a party, express or implied, or by act of the law, resulting or constructive. We are going to stop right here and continue on another day, if it be the will of Almighty God. We would like to thank you, the listening audience, for tuning in and watching our video, and we hope that it has been informative and educational to you, and we hope that you enjoyed it as well. This is actually from a book we have um, available to the public. If you would like to receive a copy of this book for a minimum fee, could you send us an email with your name, telephone number, and email address at knowyourights.univ@gmail.com. That's no, KNOW, yo, YO, rights, RIGHTS, .univ@gmail.com. Thank you for listening, and until the next time, signing out. Peace.